All right, let's dive into a fascinating case today. We're looking at a tragic car crash that happened on a holiday, but it kicked off this huge legal battle between two major companies. And the question seems pretty simple on the surface, but the answer? Well, it involves a legal twist that completely flips the script on who's really to blame on the road. So let me ask you this. Imagine an employee takes a company car, and on their day off, they get into a crash. Who should have to pay for the damages, the employee or the company whose name is on the side of that car? That's the exact problem at the very heart of this story.
So to really get what happened in the courtroom, we first have to go back to the incident that started this whole thing. Let's get into it. Section 1, a fatal holiday crash.
Now, the date here is absolutely everything. We're talking February 25th, 2003. This was not just a regular Tuesday, it was a special national holiday in the Philippines. You're going to want to lock that detail away because it becomes a huge piece of the legal puzzle later on.
Okay, so here's the play-by-play, the stuff that nobody disputes. Around 6:50 in the morning, a Greenstar Express bus is making its way toward Manila. At the exact same time, a van owned by the food giant Universal Robina Corporation, you probably know them as URC, is headed the other way. Along a highway in Laguna, they collide, head-on. And tragically, the driver of the van, Renante Bicamong, died right there at the scene.
So yeah, a total tragedy. But from a legal perspective, it all boils down to one simple but really tough question. Who's responsible here?
All right, let's get into the company's side of the story. Section 2, the company's defense. How did URC, the van's owner, argue that this wasn't their problem?
Well, URC basically said, hey, this isn't on us, and they had a whole list of reasons why. First, it was a holiday, so their employee was not on the clock. Second, they had testimony he was on a purely personal trip to give his daughter some money. Third, that van wasn't even his assigned company vehicle. And finally, the crash happened way outside his normal work area.
Their whole defense hinged on this legal idea called vicarious liability, specifically Article 2180 of the Civil Code. Now, this law says employers are on the hook for what their employees do, but, and this is a huge but, only when they're acting within the scope of their assigned tasks. That little phrase, that was URC's entire game plan. But, this was far from over. The bus company Greenstar came back swinging with a really powerful legal rule of their own. Let's look at Section 3, the Registered Owner Rule. This one is called the Registered Owner Rule, and it sounds incredibly simple. The whole point of this rule is to identify one specific person, the registered owner, who is liable, period. It's basically a no-excuses rule designed to stop owners from just passing the buck and saying, hey, talk to the driver, not me. So you can see the showdown, right? It's a total clash of legal ideas. On one side, you have URC shouting, he wasn't on the clock, we're out. But on the other side, Greenstar is firing back, nope, you own the van, you pay. The end. So what happens when two laws seem to say the complete opposite? Which one wins? This brings us to Section 4, harmonizing two legal rules. And this is where it gets really clever. Instead of just picking a winner, the Supreme Court did something way smarter. They figured out how to make both of these rules work together.
They laid out this really elegant three-step process. Here's how it works. Step 1. Greenstar, the plaintiff, just has to prove URC is the registered owner of the van. Easy enough. Step 2. Once that's proven, the law automatically presumes the employer is liable. It kind of links the two rules. And then, and this is the big move, the ball is suddenly in the employer's court. It's now up to them to prove they are not responsible. So, following that logic, just because URC owned the van, the law immediately said, you're probably liable. But, and it's a big but, the court found they actually managed to prove their case and flip that presumption.
So how'd they do it? Well, they brought out that whole list of evidence we talked about before. They proved their driver wasn't acting within his duties by showing it was a holiday, he was on a personal trip, he was in a vehicle that wasn't his, and he was way outside his work zone. All that was enough to break the presumption against them. So, case closed, right? The company wins, they're not liable, but hold on, because just when you think it's all over, the story takes a wild turn. The court then put the bus driver's actions under the microscope, and that leads us to Section 5, the surprising final twist. And you know where the key to this twist came from? The bus driver's own words. He testified right there on the record, I saw the L300 UV on the shoulder of the opposite lane, about 250 meters away from my bus. Let's just stop on that number.
250 meters. I mean, think about that for a second. That is not a quick glance. That's more than 2.5 football fields away. That is a ton of time and distance to see something is wrong and actually do something about it. And that one fact, that 250 meters, brought a whole new legal idea into play, the doctrine of last clear chance. Basically, it says, look, even if someone else messed up first, the person who had the final, clear opportunity to prevent the crash and didn't take it, well, they're the one who's ultimately on the hook. And that's precisely what the court decided happened here. It concluded that the bus driver, Saison, saw that van driving erratically from way, way down the road. He had plenty of time to slow down, to swerve, to do something. But he didn't. He had the last clear chance to avoid a disaster, and he failed to take it. Okay, so after all of that, all the legal twists and turns, all the rules, all the arguments, who actually bears the responsibility here at the end of the day? Well, check this out. Greenstar, the bus company, sued URC for damages. The court said, nope, dismissed. Why? Because URC proved its employee wasn't on duty. But then URC tried to sue Greenstar back for the damage to their van, and the court said, nope, you're dismissed too. And the reason for that? The last clear chance of their driver. In the end, because both sides had some fault, nobody could collect a dime from anybody else. You know, this case is an incredible look at how the law can navigate some really tricky situations. But it leaves us with a much bigger question to think about, doesn't it? In a split-second crisis on the road, where does a company's rulebook end and a person's own judgment and moral responsibility begin?